Welcome, I am the Loud Little Ducky. Today is going to be part 2 in the Greg Gillespie versus Laura Owens case. This is the Fiverr episode. We are not sponsored by Fiverr, but most of you will know what that means. And thank you to everybody that has subscribed so far. We're on our road to 500 and then 1,000 to start earning monetization. Not there yet, but we're working on it. So let's jump in to part 2. So now we are at about August 22nd. Owens forwards Gillespie an alleged email chain between attorney Joe Cotchett, an Owens family friend who was representing her dad in something, but also was at his retirement party, and she calls him Uncle Joe. It's weird. But attorney Allison Cordova and herself, an alleged email chain between attorney Joe Cotchett, attorney Allison Cordova, and herself with the subject urgent, copy of the conversation with Joe Cotchett, and contract. The email also includes a signed and dated contingency fee agreement for Cotchett's law firm to represent LO in a legal proceeding. So I'm going to go ahead and read this. If we come back across this section, I'm just going to skip it and say refer to the beginning of the video. So 9, plaintiff's alleged email exchange with Allison Cordova and Joe Cotchett was emailed to Mr. Gillespie on August 22nd, 2021 with the subject line urgent copy of conversation with Joe Cotchett and contract, along with the manufactured fabricated contingency fee agreement between plaintiff and Cotchett, Pittry and McCarthy LLP, dated August 23, 2021. 10. Upon information and belief, neither Allison Cordova nor Tony Stevens is currently employed at the firm, nor were they employed at the firm as of August 19th and August 22nd of 2021. So they're saying these people did not work at the firm during the dates that it was alleged by Owens they did. Just more lies. 11. Believing that there was fraud in plaintiff's underlying complaint, undersigned counsel reached out to the purported attorneys in California who appeared to completely disavow any connection to this cause, as an email dated August 24, 2021, sent on behalf of Joseph W. Cotchett, indicated that the firm does not represent the plaintiff in this matter. All subsequent emails from undersigned counsel requested to speak with Joseph Cotchett about the seemingly fraudulent emails purported authored by Joe Cotchett and lawyers that have not worked at the firm for quite some time went without any substantive response. So Uncle Jojo, didn't respond after just stating we don't represent her. He had nothing left to say after that, which is weird. He can just say, I don't represent her. Okay, well, did you write this communication? Like, whether you represented it or not, did you have this conversation with her? Can we authenticate this conversation, or was this something that was also fraudulently drawn up? Was it a faked conversation between Uncle Joe and her? You never know with her. Everything needs to be verified through any means possible. So we do have to jump back a little bit because this is stuff that I didn't cover in the last video, because there were so many other text messages. So this is prior to the unaliving talk, I believe, because I don't remember the dates on those exactly. But this is the messaging pertaining to the ultrasound. So on August 6, 2021, at 8:24 p.m., she sends him a picture of the ultrasound. It says, looks like you're going to be a dad to 1 or 2 babies. Well, did they not tell you at your ultrasound whether it was 1 or 2 babies? Because they would have told you if it was 1 or 2 babies. They wouldn't have been like, well, there might be a second one. No, they would have told you at your ultrasound appointment. If you were at a doctor, was sick enough to go to the clinic this afternoon and had to get an ultrasound to make sure I wasn't having an ectopic pregnancy. So you went because you felt sick, not to verify a pregnancy. Okay. This is not how we go to the doctor to find out about us being pregnant. I was sick, so I had to make sure it wasn't an ectopic pregnancy. Have you ever heard of morning sickness? Like, you wouldn't even need to come up with this elaborated lie as why you were sick at the beginning of a pregnancy. It makes no damn sense. Like, can't even make up believable lies. I wasn't. I found out that I've been pregnant with twins. Looks like one of them passed or isn't doing well, probably because of the medicine I took. I had the option of a surgical abortion and elected not to. If I'm going through this on my own, I will let God decide if he wants both, one, or none to be born. And the kids would deserve to know their father's side of the family. I'm giving you one more shot to admit you were overwhelmed in panic and apologize. Otherwise, you are not getting any input going forward. Your behavior is appalling. Coercing me to get an abortion for your own personal agenda. And I will escalate this if I don't hear back from you. More threats. And she's got to make sure she puts that coercing me, because she needs that for her lawsuit that she's going to file on him. She's already planning this stuff. She's already planning suing him. She already knows she's going to be taking him to court for this stuff. I talked to a lawyer who told me I can have a court order to establish paternity at 8 weeks and get child support from that point on, which is 25% of your income. I don't know what it is in Arizona. Here in Texas, it's 20%, and then a second one is 25%, and so forth. But in Arizona, it may be 25%. And I don't know if you would start getting, I guess you could start getting child support from before the child's born. Or you just send him the medical bills and he pays half. I think that's more like what happens, not that you're going to get child support the whole time you're pregnant onward. Because trust me, if women out there knew they could get child support for 9 months while being pregnant and their baby daddy don't want to step up, oh, there would be tons of women collecting on that. Tons of women collecting that extra 9 months so they could get 18 years and 9 months of child support. So I don't know that child support part is true. I think paying half the medical bill for the baby or whatever is more likely the standard. But I am not a professional lawyer or anything like that, so I don't know. It's just my opinion. You would not get custody given all you have written about aborting the pregnancy. If you also had manipulated me to take the abortion pill that resulted in the deformity or death of the second fetus, I would also pursue any and all legal action for that. If you are going to stick with manipulation, lies, and ghosting, you are not who I thought you were, and would deserve it. Manipulation and lies. Doth protest too much, Owens? I still want to believe that you're the guy who wanted a fresh start with me and to go to Sedona for it on a trip that you told me you booked a hotel for. Woman, you have been on a few dates. Not even a plethora of dates. Just a few. I want to believe. Oh, good God. Take your drama to like a stage play in your town or something. Like, go have a creative outlet or something. Perform for your horses. Something. Stop with your dramatics and your writing. I told you earlier on that you didn't need to be with me and that I would make the decision on my own, with my own timeline. But you insisted that you wanted to be with me and do this the right way. In the future, which I believed. This is your last chance to show me that you weren't coercing me to have an abortion. Where is it? Oh, to have an abortion under false pretenses. Again, keeps mentioning coercion because as of August 6th, she is planning taking him to court already. She is already preparing for this, so she's got it entered in so she has evidence. See? He was coercing me. I said it right here. I would have had the surgical abortion today if you were supporting me. I still would if you still intend to keep your word. If I don't hear from you, I'm going to go forward with the lawyer. She said the exact same thing to Gillespie. If I don't hear from you, I'm keeping the babies. If I don't hear from you, I'm talking to the lawyer. If I don't hear from you, I'm going to file the paternity test in court. And you know what? You don't have to be with the person you're having a child with. You really don't. Should you be doing it with them if you don't want to be with them or have a child with them? No. But just because you're having a child together doesn't mean you have to be together. It doesn't mean that you have to get married. None of that. You can be parents to a child, children, whatever it is, separately. Sometimes people think it's best for the kids, but I'm going to say don't do it for the kids. Because if you're truly not happy and you truly don't want that, that's not best for the kids. The kids need to see both parents happy, whether that's apart or together. It's what they need to see. And show them that, you know what, just because, we didn't work out, I still love you. I'm still putting you as a priority. I don't have to work with your mother, but I'm going to still be there for the baby. That is for future people who get pregnant. That is not for this situation. Because I would do a psych evaluation and get custody of this child from Owens if I was anybody, if there was real babies. And here she also talks about, I would get a surgical abortion. But yet with Eckerd, Clayton, she is like, no, I would not get a surgical abortion. That is one thing I won't do. So here you're for it. So why are you not for it now? What changed your mind about a surgical abortion as opposed to just a pill abortion? It just doesn't make any sense. Here's what I did. I made an appointment for a surgical abortion as well as one with the attorney to go over specifics, so let me know which one you want me to cancel. I guess you're right that I don't know who you are, so show me. Gillespie responds back, you're going to birth a baby with birth defects? You took pills. It says, I won't know until later on what the issue would be, if any. Okay. Okay. I'm telling you right now that if there was something wrong with that ultrasound, she would have been notified. Somebody would have told her. You know why? Because the woman with that ultrasound, the real woman behind that ultrasound, was told exactly why the ultrasound looked like that. It wasn't just like, maybe there's one, maybe there's two. No, they wouldn't have done that. They would have done more tests. They would have figured out more things. It wouldn't be like this. This is not how any of it works. So like I said, she said, I won't know until later on what the issue would be, if any. So what do you want to do? It clearly affected at least one, considering how small it is. It's one baby. And then she sends the picture of the small baby. August 23rd, Gillespie retains attorney Greg Woodnick to represent him. This is when Greg, with 2 G's, entered this case. And he has had to deal with this woman ever since. To represent him on the case, attorney Casey Bowman informs Owens via email that Greg Gillespie has retained Woodnick Law Firm to represent him in the case and states that all future communications from Owens to Gillespie should be directed to the firm. Bowman also asked Owens if she would agree to take a prenatal paternity test at Arc Point Labs. This is how she knows about Arc Point Labs when she mentions it to Clayton. Because that is the first place she mentioned. And then I guess they found out that they didn't do twin paternity tests. And so that's when they had to go with Rabgen. Says Owens responds to Bowman saying she plans on filing a separate family court case and would be willing to take a paternity test. Owens also states that she has spoken informally with the attorney who plans to represent her in the current case about text messages she received from plans to represent her in the current case about text message. Okay, I just read that twice. Plans to represent her in the current case about text message she received from Gillespie the night before. Owens ends her email with, he can contact me at phone number if he rethinks his decision regarding a relationship and if he would like to be a part of a pregnancy decisions going forward. The same day, Woodnick emails Joe Cotchett to verify whether his firm is representing Owens in her case against Gillespie. So he's trying to figure out if Joe Cotchett is her attorney, because that is the attorney she's been having a conversation with. Or that she's produced the messages to say, see, I talked to my Uncle Jojo. Like, see, he knows. He's very famous. You know, like just bragging about what an amazing attorney he is. But she doesn't look like, I don't think she ever filed, from my understanding, a family court case against Gillespie. But she ended up doing it with Clayton. So, you know, that's why she can say, well, I have never filed paternity suits in any of those other cases. That's why they're not identical. It doesn't matter what kind of case it was. You filed cases in court. You filed things in court against all these men. You just might have changed up the type. So then we've got on August 24th, Woodnick receives a reply from Cotchett's firm stating that they do not represent Owens in the referenced matter. And August 27th, Woodnick's paralegal emails Owens, "You should receive an email from Arc Point Labs of Scottsdale later today setting your appointment for a non-invasive prenatal paternity testing for next week." Now, I don't know. No, never mind. So they've got all this set up. She's going to be getting her appointment for this paternity test. We're verifying Uncle Joe. And Woodnick is on the case right now. All right, so here we have a response to plaintiff's motion to seal court records assigned to the Honorable Judge Bacchus in the state of Arizona and Maricopa County in the Owens V Gillespie matter, stating, "Defendant Gregory Gillespie, by and through undersigned counsel, hereby responds and objects to plaintiff's motion to seal. Plaintiff's motion fails to meet the requirements to seal pursuant to Rule 5.4 Arizona Rules of Civil Procedure, and only serves to highlight why the matter must be dismissed pursuant to the pending Rule 12b6 motion. This response is supported by the following memorandum." And the memorandum starts by 1. Rule 5.4 controls sealing of court records. Rule 5.4 Arizona Rules of Civil Procedure permits the court to seal the court record upon the finding of the following grounds. C. Order permitting a document to be filed under seal. 2. Requirements. Unless a statute, rule, or prior court order authorizes a document to be filed under seal, a court may order that a document may be filed under seal only if it finds in the written order that A. An overriding interest exists that supports the filing of the document under seal and overcomes the right of public access to it. B. A substantial probability exists that the person seeking to file this document under seal or another person would be prejudiced if it is not filed under seal. C. The proposed restriction on public access to the document is no greater than necessary to preserve the confidentiality of the information subject to the overriding interest. And D. No reasonable, less restrictive alternative exists to preserve the confidentiality of the information subject to overriding interest. Now we're going to get into the background. So it says plaintiff filed her complaint on August 11th, 2021. So a couple of days after that August 6th text message with the sonogram picture where she's talking about all about the coercion. Alleges she became pregnant with defendant's child on their second date. Instead of properly filing a paternity action pursuant to Title 25, plaintiff's complaint contains bizarre allegations. Among other things, plaintiff alleged defendant forced plaintiff to have multiple pregnancy tests and a doctor's appointment. Forced her to take pregnancy tests and a doctor's appointment? Shouldn't you want to do that if you found out you're pregnant, whether you want to keep it or not? Like, you kind of need to know those things to go to the next step. Forced. My arse. And defendant employed false promises and verbal and emotional abuse because he blocked her. Plaintiff's preposterous claims of abortion coercion is addressed in the defendant's motion to dismiss filed on September 24th, 2021. The salacious allegations were presented by plaintiff in her pro per complaint as a brief summary for this court. So we're going to go over the summary. And apparently in September, there was Gillespie tried to dismiss this abortion coercion thing. And I guess it got denied because here we are in October and we're still filing documents, unfortunately for Gillespie. Plaintiff Owens provided a sonographic image to defendant Gillespie on August 6, 2021, Exhibit A. A reverse Google image search revealed the images were identical to a sonogram found on a blog post from 2014. Exhibit B. Plaintiff sent defendant a fabricated email exchange on August 22, 2021, purportedly being between herself and California attorneys. One of the attorneys and the legal assistant on the exchange were not employed at the firm at the time of the alleged emails, and the law firm has denied involvement in this matter. Exhibit C. 3. As absurd as it sounds, plaintiff has attempted to weaponize this civil litigation in order to force the defendant, Gillespie, to date her. Yep, we know that's her modus operandi. On August 23, 2021, plaintiff informed defendant's counsel the defendant could contact plaintiff if he rethinks his decision regarding a relationship. Why would you send that to his attorneys? Like, why would you say that? Like, there was no reason for that. I'll drop this lawsuit on your client if he wants to rethink a relationship with me. Like, no wonder Woodnick is tired of her BS. Because this is how his interaction started, was with that line right there. Rethinks his decision regarding our relationship. In an email to defendant's counsel on August 23, 2021, plaintiff states, if he chooses to stand behind his words, I will file to dismiss with prejudice all charges related to case file and not file a criminal and family law cases. All I'm asking him to do is keep his word. If he does that, everything will be dropped. He can contact me at redacted if he rethinks his decision regarding a relationship. Exhibit D, emphasis added. On September 1st, 2021, defendant through counsel informed plaintiff that she would be facing fraud allegations, counterclaim for what has occurred, and that it would be wise to abandon her malicious claims to end this nonsense. See Exhibit E. 3. Plaintiff's motion to seal is deficient. Sealing a case is reserved for matters that are an overriding interest exists to support filing the document under seal. Here, a self-aggrandizing podcaster, ooh, that's a big word, Woodnick using his word of the day calendar or toilet paper, who has refused a paternity test, ignored Title 25, doctored images, and who may have entered into this bizarre, nonsensical civil suit as a fodder for her podcast, is not entitled to Rule 5.4 relief. No, she just wants all this stuff hidden because she doesn't want people to be able to find this stuff. She wants to just lurk in the shadows. Well, she has lurked for 10 years. And you are now out in front of the shadows. You don't get to lurk anymore. You don't get to ruin any more men's lives. Rather than allege an overriding interest, plaintiff states she is a popular self-help podcast and victim's advocate, which is the scariest thing I have ever heard. This woman who likes to emotionally terrorize people is helping others in their emotional journeys. She's giving advice to people and real victims with the crud she has done. It is unfathomable. Like the audacity. Plaintiff also alleges that her desire is for any money won to be donated to women's charity, and that she does not wish to have her pure intentions and desire for justice to be public. Oh, is she gonna, so she wants to pledge the money to a women's charity? Okay. Well, Greg, don't write a check to her. Just write it to Women's Charity. She filed the confounding complaint, and this is certainly not an overriding interest. Plaintiff's purported career and popularity is insufficient grounds. Agreed. People are filing, more people's information and stuff like that is out there, and it has more grounds than this one. Like, just because you don't want people to know about this and you don't like people to know about this, well then, maybe you should have thought about all that. So sorry. We have a right to know as the public what type of people are out there. That's for our own benefit. Because anybody that wants to do a background on Gillespie or Owens, they have the right to know if this person has ever had court cases on them and to look into it for themselves if they want to. Or to see if Owens is credible. Like, that stuff can't just be hidden. Like, can you imagine if, because a popular person, murdered somebody, that, well, I'm popular and I'm a celebrity, so, if we could just keep this sealed and out of the public eye, that would be, really great. Because, I'm gonna lose brand deals over this, and I don't want all those honeys out there knowing that I murdered somebody. So if we could just keep this on the DL courts. No, that's not how that works. Let's see. Further, plaintiffs now request the court seal only defendant's motion to dismiss, despite stating that her complaint was an extremely private nature. Plaintiff's complaint created the very problem plaintiff now seeks to make private. She had multiple opportunities to dismiss the matter. See Exhibit E. Clearly, the defendant's motion to dismiss showed plaintiff that her complaint backfired and that the defendant is not going to be forced into a relationship with her. The plaintiff seeks only to seal defendant's motion to dismiss, demonstrates plaintiff knows she has been caught fabricating allegations and that she will be facing allegations of fraud in a public court forum. Plaintiff cannot benefit by having defendant's motion to dismiss sealed and have her salacious complaint remained unsealed. Yeah. Court, if you could just keep all my bad acts on the DL, that would be really great. No. We don't want to, we don't have to keep his bad acts on the DL. Let everybody know about those. But, me, I'm a podcaster. My stuff has to say secret. Shh. Hush, hush. It's insane. This entire litigation is nothing more than a paternity action. If she is actually pregnant and there is a pending motion to dismiss because plaintiff has not stated a legal cognizable claim, plaintiff's motion to seal is an overt attempt to further her fictional narrative and possibly even a ruse to gain more podcast followers. Plaintiff simply cannot be permitted to seal defendant's motion to dismiss because it reveals the false nature of her behavior. The court need merely look at Exhibit A and Exhibit B. Wherefore, defendant hereby respectfully requests the following. A. This court deny plaintiff's motion to seal court records. B. That this court dismiss plaintiff's complaint in its entirety with prejudice. C. This court award defendants his attorney's fees and costs pursuant to ARS 12-341, 12-349, and Rule 11, Arizona Rules of Civil Procedure. And D. That this court grants such other and further relief as deemed appropriate. Respectfully submitted the 6th day of October 2021. Signed, Woodnick Law was sent to all the right people, and Gillespie signed that this was true and correct to the best of his belief under the penalty of perjury. And the first two pictures are the exhibits. We've gone over this text. This is the text that she sent him on August 6th. Then, here is the picture. The top picture is the original picture. It was done based on a last menstrual period of November 12th, 2014. 5 weeks and 2 days. This is the original. Then we have Owens Arts and Crafts down below. So she puts her name on it. She puts this GE thing around it. Family Planning Associates. I don't know if anybody's actually looked into them or if they got like a HIPAA release from Family Planning Associates, because I think they should. And this, she says it was done on 8/6/2021 at 14/22/03. And then it's got the ultrasound image inserted into it. To me, what is kind of weird here is that so right here is the ending of this picture where this little bar is right here. But the ultrasound goes over the bar. Like that would not happen. Like the bar is completely separated from this. They don't run into each other on a real ultrasound. So that's fake. And this one, she's got it cropped, or it's just, you can't see it in this, but in the first one, you just have the dots. You don't see the bar in this text message here. But in the exhibit, you do. You see this bar and that the ultrasound is overlapping over it. Rookie mistake, I guess. And then, of course, I zoomed in on the text, and we have the Fiverr logo right here. Got the dot, and the R, and the R, the F, V, E. There's our Fiverr logo that we have here. And then, you know, we can erase that. But you can clearly see it right there without that on there. Clearly see this Fiverr logo. All right. So those are the exhibits, and then the zoomed in Fiverr logo. All right, here is, this is from Gillespie, and it's to Casey Bowman and Greg Woodnick. It is a forward. It says urgent copy of conversation with Joe Cotchett and contract, and then it's attached Cotchett contact Owens PDF. So Gillespie sends this to Woodnick and Bowman. And then, of course, it's got the from Owens with the August 22nd date, 2021, and to Greg. So Gillespie forwards this over. This is what Owens sent Greg, and then Greg sent off to his attorney. Hi, Uncle Joe. First of all, I hope you had a great weekend and that the smoke didn't get as bad on the peninsula as you thought it would. I miss our dinners and hope you get out here soon. Although I've yet to find another House of Prime Rib, so lower your standards for now. Again, thank you so much for the enormous help you've been in this sad situation that I am. Again, thank you so much for the enormous help you've been in this. Okay, there needed to be a punctuation in there. You've been in this sad situation that I am in. Here's where I'm at. After many emails, I heard from Greg this morning. He wanted to discuss things tomorrow at 7 p.m. I was surprised, but certainly wanted to give him the benefit of the doubt, since all I've wanted is for him to keep his word. Since his initial message, I have sent more messages that I know he has read and that have been left unresponded to. Got that mail tracker. As much as I wanted to give him more and more chances, I don't think he wants them. No, I don't think he does either. So at least you half understand. I think the best call is to pursue alternative services, alternative services. Yes, sometimes we pronounce words wrong and we get tongue-tied or we read too fast. Sometimes I actually read it right, but it didn't make sense because of some grammar. But I read it the way I read it, and I correct it, and I'm not going to edit it out because that's just me. I'm not going to edit myself to look perfect. So I hope everybody can understand that I am just doing this just plain, and I'm not going to edit to do it and take out all my mistakes. I'm going to leave them in because it's just part of who I am. And try to get him twice. Once by posting on his house door and the other by calling his company and finding a coworker to serve him. I think you're right that you would be better at making those phone calls than me. I text you the coworkers who we could ask to serve. Once that happens, we can file for punitive damages like you recommended. I really do stand firm in staying under $100,000 in punitive damages. But I guess it also depends on the damages to the child. Although, wouldn't that also be covered in family court? Why do you want to stay under $100,000, Jane? So somebody can't come back on you for that money because it's not over $100,000? It's a weird statement to make because most people, when it comes to punitive damages, they don't care how much it is over the price that they want. They would take $100,000 and plus in punitive damages if they were truly done wrong and deserved it. But you want to put a cap on your punitive damages. It's a bizarre statement. I will think about what you said about trying to go for a settlement straight out of the box. I don't want to play this nasty. Oh, girl, you are nasty. You are so nasty, dirty. You are the queen of nastiness. Honestly, I just wish this never happened and that we could just be happy like he said we could be. Girl, you have never said anything honestly. Here's hoping he proves me wrong. I'm giving him one more chance. Girl, refer back up to a couple of statements earlier where you even state, I don't think he wants the chances. So don't give him any more chances. Love, Laura. And this is from, so she sent that back to Uncle Joe at 10:49 no, I'm just kidding. I'm just kidding. But Joe Cotchett, to Owens, and it says on August 22nd at 7:42 p.m. So this is a couple of hours prior to her sending this to Gillespie. It says, subject sent on behalf of Joe Cotchett, re Laura Owens pregnancy, importance high. Is Uncle Jojo marking things as high importance to send to Owens? Like, why does he need to mark that as high importance? Why can't he just send that as a regular email? Is it so Owens can find this easier and not have to deal with everything else in her inbox? And the thing on the from Joe Cotchett that is interesting to me is if you look at Greg Gillespie and Owens, they have the email address, but on Joe Cotchett, it doesn't have his email address. And we can add our email contacts into these things and put any email under there. It could be chasejjones@gmail.com or fake Joe Cotchett or Uncle Joe Cotchett @gmail.com, and then you save that as Joe Cotchett. And so you would just click on your Joe Cotchett name and it might not put that in there. But you can also see that from is here. Like a huge gap in between from and sent. I don't know what this was, why there's a huge space here. But you've got from and sent here and from and sent here. Those are not spaced out like this. So what is this about? So the email states, Laura, what's the update? I'm ready to get started on this the second you give me a go-ahead. As much as I want this guy to be exactly the man he's told you that he is, I am not convinced that he is. I am always here for you and the whole Owens family. Why would he type the Owens family? Like, that's a weird way to word it too. Like, why wouldn't he just say you and the whole family? Why does he have to put the Owens family? I mean, I may be just over analyzing things. That's just something I do. But that just is weird to me as well. Whenever you need me, and if you want me to go after this guy, I will make this case a top priority. Shh. Because I really feel for you right now. Why are we shushing? Allison sent me over the retention agreement and medical file. Every test result that came into our office matched what you had said. You have an easy open and shut case. This guy has nothing going his way here, and I think he could and will continue it on. I don't know if lawyers say that every case is open and shut. Especially with an abortion coercion case. That wouldn't be an open and shut case. Like, that one's probably, and it wasn't an open and shut case. So this lawyer is telling her it's an open and shut case too? Red flags everywhere. Red flags everywhere. You know what? We're gonna draw a red flag. Yep. Got our red flag here. Drawing The red flag colored in. Yep. Red flags everywhere. Red flags everywhere. This whole email is a red flag. Now, provide for a real landmark case regarding abortion coercion. This may be very needy, and we could make this a public interest story with the snap of a finger. So Cotchett wants this to be a public interest story. But then Jane Owens, I don't think she deserves privacy, wants to seal records about her. But when she was looking good, let's put this, her and Uncle Jojo thought about making it a public interest story. Just like that. Just like she did with Clayton. When it made her look good. Now, she wants to seal records in the Gillespie case. Now, she hates all the attention she's getting from the Justice for Clayton cult. You only want the public interest story when you look good. And there's no takesy-backsies. However, in your interest, we could also just follow for judgment immediately. I think that's file for judgment immediately, so that you could start receiving money immediately. It's all about that money, honey. Remember, any man would feel like the luckiest man alive to have you by his side. You were polite, kind, and thoughtful as a little girl. And those qualities got even better as you got older. Regardless of what happens, I am by your side. Uncle, smiley face, Joseph W. Cotchett. Founding partner, Cotchett, Pittry, McCarthy, LLP, and then it talks about it, confidentiality. So now we go down to from Allison Cordova. Sent, well, see, I can take out what I said here. No, maybe I can't. I don't have to take it back. Because, once again, this is somebody that works at Cotchett. And we've got this from a huge space here where she's either blocked this part out where her email is or something, because there's a huge space once again between the from and the sent line. Thursday, August 19th, 2021 to Tony Stevens and Owens. Sent on behalf of Joe Cotchett, Laura Owens pregnancy, importance high. So we got that marked high importance. Laura, please see below. Joe's secretary informed me that we had actually received medical authorization from you. Thank you. Everything you told us about pregnancy tests and ultrasound aligned with the timing you provided us. There were no past pregnancies on your record. And the 3 obstetricians you saw felt that the pregnancy was consistent with intercourse that took place between June 30th and July 1st. Nobody would say that. Nobody talks about intercourse and pregnancy like that. They would stay based on your last menstrual period. And once again, she's gone to 3 OBs. Did Gillespie ever get HIPAA forms done on this? Because I think he should go back and do it. If he didn't do it in this other case, when he comes back to sue her for other things, he needs to get these HIPAA releases from these 3 obstetricians. and that medical people, that medical ultrasound group written on there. Like, oh my God. Poor Greg. Both Gregs. I think they knew that this was fake, but because it wasn't a paternity case, they couldn't. They're men, so I don't know. They also stated that the abortion pills will play a big role in your child's development. They don't know that. There is no way to fully know that the development of the child is going to be affected by the abortion pills. It could, but until that baby's born and you start looking at their milestones, they have no way to tell what this child's development is going to be. Could he be a preemie? Could he come out early? Could he possibly pass? Yeah, that could happen whether you took an abortion pill or not. But even with an abortion pill, and you make sure, because this would make her, to me, a little bit of high risk if she decides to keep it, because they would want to keep monitoring the growth of that baby. But I don't think that they can call whether it has a huge role in this child's development or not. And why not the other one? Because it's just untouched. It only touches one. Just because he's growing, maybe the one that's big is the one that has problems and the little one is the right size. Like, you don't know, because this isn't a real scenario. None of this happened. It must feel like you have had the weight of the world on you, but have no doubt the jury will sympathize with your situation. Is there a jury in this case? Was there a jury? Or was this a bench trial once again? The next step is to fill out the attached retention agreement. Thank you, best. Allison Cordova. Okay, so an associate at a law firm is signing her emails with best, comma. Not all the best, just best, comma. Yeah, that doesn't raise any flags, does it? Nope. No red flags to see here. None whatsoever. This is a load of BS. Contingency fee. I like how all of the initials look exactly the same. Like, and they're all like spaced above the line in a certain way. Like, I don't know about you, but my initials, if I had to sign my initials this many times, I don't think that any two of them would be the same. They would all be similar, but identical? Nope. In consideration of the legal services to be rendered by law offices of Cotchett, Pittry, and McCarthy, LLP, and the advancement by them of all costs necessary to the prosecution of all claims against party responsible for injuries and damages sustained, Owens, on or about June 30th, 2021, the undersigned client employs said attorneys to commence and prosecute said claims. Initials, Owens. Attorney's fee. Client agrees to pay attorney's fees on the following basis. It is understood that no specific fee is set by law and that this fee has been specifically agreed to between the parties. The sum of 23% of the net amount recovered by compromise or trial. Net amount recovered is the sum received from the responsible parties after deductions, signed or initialed. 3. Attorney's fees on structured settlement in every client's recovery will be by some form of periodic payment. The lawyer's fees shall be based on the estimated percentage value of recovery. These fees shall be due in full immediately upon a settlement verdict or upon entering into a periodic payment agreement. Client agrees that lawyers shall not be required to recover their fees as a pro rata share of the periodic payments. 4. The said fees do not include fees for appeal and or retrial of the case. In the event an appeal is prosecuted and or retrial is ordered, additional fee arrangement will be negotiated between the parties. 5. Associates counsel may be employed at the discretion and expense of the attorneys, but these associate counsel fees shall not be an additional expense to the client and shall be deducted from the fees paid to the law firm. Attorney costs. The law firm shall advance costs as their judgment are necessary for prosecution of these claims, and these costs advanced shall be returned out of the recovery in the case. These cost advances may include, without limitation, travel expense, photocopying charges, long-distance telephone expenses. Somebody needs to update their thing. Is there long-distance telephone charges now? Do we still have those? I mean, I guess we do. I didn't really think that was much of a thing anymore. Granted, people sometimes don't update their stuff. It's also fake, so, you know. The attorneys may, in their discretion, employ outside investigators and other experts whose fees shall be charged as advanced costs. Attorneys' lien and special power. Said law office of Cotchett, Pittree, and McCarthy, LLP, is hereby granted a lien upon any recovery for all sums of money advanced by them for attorneys' fees and costs. The attorney is granted the client's special power of attorney to endorse all documents in the client's name which are necessary to finalize or complete the settlement, including the endorsement of a check and or draft. Attorneys do not have the authority to decide whether to settle or compromise clients' claims without the expressed authorization of the client. It is agreed that the law firm may retain fees and costs out of the amount finally collected by a settlement or judgment. Representation. Is it acknowledged that the law firm has made no representation whatsoever regarding the successful termination of said claim? No representation whatsoever regarding the second. Okay. Whatever. I don't actually know what that last line meant. If somebody knows what that last line meant, let me know. Okay. So, what's kind of interesting that it's something that's not in this. It may be in the next page, but so far there's nothing about if there isn't any money given in this case, how she has to pay. Is that automatically in the periodic payment that she has to enter into, or because that just says on a structured settlement and so in the recovery of the money and stuff once they have the settlement. This doesn't cover if she loses and doesn't get a settlement offer, which that should be in this too, but it might be on the next page. We'll see. Waiver of jury trial regarding dispute between client and attorneys. By agreeing to arbitration of disputes relating to this agreement or attorney's performance of service hereunder, client acknowledges that 1. Client is waiving the right to a jury trial as to disputes. 2. Parties' ability to conduct discovery or get information is much more limited in arbitration than in a court proceeding. And 3. There is limited appellate review of an arbitration. Client is knowingly waived the right to a jury trial of any dispute with attorneys relating to this agreement pursuant to these things. Client also knowingly waives the right to the full extent of discovery and appellate review that would apply if such a dispute were brought and litigated in court. Right to seek independent legal advice. Before entering this agreement, Cotchett, Pitry, and McCarthy LLP have specifically advised client of his or her right to seek the advice of an independent attorney concerning the terms and conditions of this agreement. Client has been encouraged to seek such independent advice as he or she desires concerning any questions to this matter. Insurance coverage. The law offices of Cotchett, Pitry, and McCarthy LLP maintain errors and omissions insurance applicable to legal services to be rendered. Dated Scottsdale, 23rd August. Duplicate copy of this contract has been provided to me, Laura Owens, which that's not a real signature, that's a computer signature. And Joe Cotchett for Cotchett, Pitry, and McCarthy LLP, and that's not signed. You know what? I'm going to send this agreement over to Legal Vices and see what he has to say about it. I want him to look at this and see what he thinks about it. All right, now we're going into the email. Sarah Seberg from Owens, sent Monday, August 23rd, 2021, 2:23 p.m. to Casey Bowman, and then the case number. Here we've got the normal spacing from and sent, not that big line. And also that agreement didn't cover if she loses this case and how the money is going to be collected for this case. But anyways, okay, to this email. Miss Bowman, I want to be clear that the reason I am filing this specific case number against Mr. Gillespie is because he coerced me into taking abortion pills and the personal damage I have suffered as a result of it. I am planning on filing a separate case this week through family law court. I would, of course, be willing to have a prenatal paternity test done at ARC Labs when I am able to, which they say is when the pregnancy is at least 9 weeks along. The only 2 times I have had sex since February 2020 were with Mr. Gillespie. With him and I were June 30th and July 1st. There's no question that my pregnancy was as a result of intercourse with him, and I would be happy to prove that. In fact, I asked him in writing many times if he would do that. I just want to make sure that we keep these separate, regardless of whether or not the pregnancy had survived because of the abortion. At Mr. Gillespie's coercion, the result would be extremely damaging, either resulting in no child when I was clear that I wanted to proceed with the pregnancy on my own, if not for his presence in my life, or one likely compromised child, and possibly a second that did not survive. As a result of his pressure tactics, quite frankly, I don't see how either would work in his favor. You kept saying, I don't see how anybody could come to coercion on this. Because she kept saying, I'm willing to get rid of the babies, all for love, all for you. I'm just willing to get rid of them. I'll throw these babies in the garbage right now. You know, who cares what the Bible says? Like, who cares what my grandma's problems were? Like, all for you. I will do it all for you. Just trash these babies right now. How are you coercing somebody who has thinking like that? Because they are already thinking it. They're the ones who brought it up. I'll get an abortion. I just don't see how that works. I will be amending the current lawsuit for an additional punitive damages of $75,000. I would never waste my time and energy filing a lawsuit were it not for the fact that his actions were not only morally and ethically wrong, but they destroyed lives. Girl, that's all you spend your time and energy on is lawsuits that are morally and ethically wrong and destroy lives. That's what you do. That's not what they do. He was very clear on the impact this would have on me if he were to leave after the abortion, and it is all documented. I have spoken informally today with the attorney who I planned to represent me in the case, and he was concerned about the motives behind Mr. Gillespie's message yesterday. He said that I had been very clear in my messages to him that I did not want him to contact me unless he wanted to maintain the promise that he made me in order to get me to have the abortion. He said that he thought it was odd that Gillespie would have asked to meet up. Responded to my statement that I did not want to get together for any other reason than what I had written him. And then responded with a time, only never to follow up with where or why. He had clearly hired your firm's services at this point, and based on his lack of response, did not want to resolve this privately. So it seems probable that he wanted to lure me into this dangerous situation. What? Gillespie hired an attorney to lure you into this dangerous situation? What the hell are you talking about? She goes on to say, this isn't unrealistic of me to think, given many threatening, intimidating texts he sent me to get me to take the abortion pills. In my complaint, and his strong desire not to have a bastard child. I also have legally admissible evidence of him telling me the night after I took the pills that if he were to see me, he would call the cops and have them take care of me, if he hadn't already done it himself. Can I see that text? Or has that text been taken out of context? The attorney is worried for my personal safety because he believes Mr. Gillespie will stop at nothing to ensure that this child is not born. Please consider the situation that I was in. It was beyond cruel to coerce someone to get an abortion and then the day after call them a psychopath. If the shoe fits. For believing that a relationship with me was what he wanted. Block them on every form of social media and then say that if they were to be contacted, they would take these sort of extreme actions. It is beyond cruel to do that. Don't be blocking people on social media. It's very cruel. He also told me for days how sick he was with COVID. And he had me walk into a trap. He complained early one evening that he felt terrible, then was unresponsive. I kept asking him if he was okay, and I wondered if I should come by to make sure if he was okay, with a mask. My dad is very compromised, and I don't want him to get sick. Around 11 a.m., I decided to come by there on my way home from the gym, which was 3 minutes away. He didn't respond to repeated knocks on the door, and I didn't know what to do. I've checked on people before, but they have always been okay, and honestly, I had no idea what a person is supposed to do. He didn't invite you over. You don't go to his house. Maybe call somebody and ask if they can go check on him, or if they've heard from him. But this is not a trap. He said, I'm not feeling great today. Probably to let you know that he didn't want to hear and deal with your BS today. And then he put his phone away to sleep, get some rest, and maybe try to feel better, and ignore his phone or you, because that doesn't make anybody feel better. It was not a trap to get you to come over and look crazy. You made yourself do that. You made yourself look crazy all by yourself. You went over there by yourself. It wasn't a trap. Get over the importance of your own self. You're not that important. I didn't know what to do if they suspect otherwise. I didn't know if I should call 911 or what. But it was a very helpless situation. I stayed for 20-30 minutes. Then I got a text from him as I was driving out saying he was sleeping and asked me why I would come by. I explained to him that since he had COVID badly and didn't respond to messages, I thought he might be dead. He responded by saying people don't die from COVID. Well, we know that that's not true. I am not getting into a political argument over that. Please don't discuss that in the comment. That is not what any of this is about. Unbeknownst to me, he was there the whole time, and he had sent a photo of me at the door, clearly clueless as to what to do. The day after the abortion, he said he could file harassment charges for me being at his door. I walked into a trap. I am unsure what his intentions are with me, but it seems to be calculated in his actions. The man told you he was sick with COVID. And you went to his house without an invitation. Y'all had been on a couple of dates. And you're just showing up at his house. Y'all weren't even, exclusive. Y'all had just gone on some dates. And you're just showing, oh my God, woman, get a hold of yourself. Ladies, don't do this. You can offer to bring them some soup and offer that, but until they wake up from their slumber or whatever and say, oh yeah, that would be nice, or if you want to, I don't care, then. But don't just go showing up at people's houses. And if you think there's an emergency, then call 911. Love to see the officers and the firefighters' faces with that call. Unfortunately, there is no evidence or indication that Mr. Gillespie meant to keep his word. I have never wanted to be wrong more so than I do now. Really? Not with Matt. Not with Michael Maraschini. But with Greg. Okay. I most certainly did not force him into a relationship or to love me. Why is love even in your vocabulary at this point? You shouldn't even love him. It's been a couple of dates. I told him many times that I thought he didn't like me or even hated me, and he said I was talking in circles and that he had been consistent in his decision to be with me. If he didn't like me, he could have just let me make my own choice. I told him that I was more than fine with that. No, you weren't. No, you weren't. You kept pushing and pushing and pushing. And he didn't have a choice. It was be with you and be miserable. Or not be with you, but have these babies and be with you, have to deal with you for 18 plus years. What kind of choice is that? Granted, if this was a real scenario and there were real babies, that is a choice that you have to make. Some guys don't want to deal with either one of those, and so they decide to walk out. It's not great. Those are shitty guys. But those are their choices. If he had to pay child support down the line, he could have been a man, paid it, and avoided me. You wouldn't have let him avoid you. Like, he would not have been able to avoid you for 18 plus years. He would have to see you at pickups. He would have to see you at graduations, weddings, when the grandchildren are born. You sadly don't really get to fully avoid your ex or your baby mama, your baby daddy that you're not with anymore. It doesn't work that way. Let's see. He could have avoided me. That would have been fine. He knew my strong desire to keep the pregnancy because of my faith and clearly acted with evil, selfish mind to get me to do what he wanted at any and all costs. I didn't force him into a relationship, but he did force me to take abortion pills. Medical abortion pills. If my legal counsel was incorrect in thinking Mr. Gillespie's text messages sent yesterday regarding meetings up for tonight was malicious, intending to cause physical or emotional abuse, please let me know. I would love nothing more than for him to be the man who I thought he was, and blame his actions on a breakdown because of his COVID and stress. If he chooses to stand behind his words, I will file to dismiss with prejudice all charges related to this case and not file the criminal and family law cases. He can contact me directly if that is the case, and we can move forward. I am very clear of my motives and stance. This has nothing to do with money and everything to do with being a man of integrity. All I'm asking him to do is keep his word. If he does that, everything will be dropped. However, it seems to me that he did whatever he could to get me to have an abortion and say whatever I wanted to hear in order to get me to do that. It doesn't seem like a good idea for him to enter this case trying to defend himself when there is so much evidence that he lied. Ma'am, we got pictures that you lied. We got photos. Probably could get HIPAA releases. I don't know if they did in this case. That you lied. But yet here you are, 4 cases later, still defending yourself with so much evidence that you lied. So yeah, how dare they try to defend their words? If indeed his intentions were at best cruel and manipulative and at worst dangerous. Greg, you're so dangerous. Oh boy. You are dangerous. He's a bad boy. Then I would like to know how he can be served for other cases that would presumably not be handled by your firm. I am sending a copy of this to him to get the information regarding other cases without contacting him privately. My process server said that Greg was home each time he tried to serve him, and I won't go through the same fruitless process again to serve additional lawsuits. I would appreciate an address that would be best to serve him at. I hope that he is who he claimed to be at the start of this process and not who he seems to be now. I will leave it up to him to decide how he wants to move forward, and if he was lying so elaborately that he would take a $120 lawsuit, a criminal law case for domestic violence, a family law case to establish paternity and child support, and resulting in legal fees, over being a man of his word. If he is going to stand behind the lie, I would like nothing. I would like to know his intentions behind texting me yesterday. You wanted to keep it under $100,000? Or is that just the punitive damages? I don't know if it matters. I'd like to know. He can contact me at redacted if he rethinks his decision regarding a relationship and if he would like to be a part of the pregnancy decisions going forward. All the best, Owens. He does not have to be in a relationship with you in order to make decisions regarding the pregnancy. You need to get that out of your head. That does not have to happen. If he does not want to be with you, he does not have to be with you, whether you're pregnant or not. He can make that decision. Continuing on with other parts, says Monday, August 23rd, 2021, Casey Bowman wrote, Miss Owens, attached hereto are the notice of appearance and acceptance of service that we e-filed this morning along with confirmation of the filings we received. We will be sure to provide you with conformed copies as soon as we receive the same. In the meantime, it appears from a brief review of the pleadings that have been filed to date that a non-invasive prenatal paternity test should be ordered. Gillespie is willing to pay for that test. Please let us know if you are agreeable. If so, we believe that Arc Point Labs in Scottsdale can administer the test, and we would be happy to contact them and forward additional details about the testing process. I'm attaching Arc Point's website below for your review. Thanks in advance, Casey. From Casey Bowman on Monday, August 23rd, 2021. Earlier that morning, and she CC'd Greg on it. And the case number is the subject line. Miss Owens, please note that we have been retained to represent Gregory Gillespie regarding the civil complaint you recently filed in Maricopa County Superior Court. We will be filing a notice of appearance and acceptance of service of the complaint today. Therefore, please direct all future communications to our firm. Or, if represented, please provide us with your attorney's contact information so that we can communicate with them moving forward. KCY Bowman, Esquire. And see, and that's what you're supposed to do. And so, if Joe Cotchett was the one helping her, or was her attorney, or whoever her attorney was for this thing, which obviously she signed a retainer, a fake retainer, but they never filed a notice of appearance with the court saying, hey, yeah, I am Owen's lawyer. So for the courts knowing and everybody else is knowing, she doesn't have an attorney. All right. And then it's got this thing, and then it's another email from Sarah Seaborg, or Sarah Seaborg is CC'd on it. It's from Woodnick on Wednesday, September 1st, 2021 at 10:11 a.m. Laura, you should have received confirmation data from Arc Point regarding the prenatal paternity test. As I trust you will be advised by counsel, it is your choice to participate in the testing at this point. As litigation proceeds, that will not be the case, as the court will order the same pursuant to ARS 25-814 and relevant case law. You should be in receipt of our notice of appearance. The court issued permission for alternate service, but that is not necessary, as we have notified the court that we represent Mr. Gillespie. We are in the process of drafting a response to your complaint and counter petition. You can avoid both litigation expenses and exposure to your sizable civil judgment by promptly filing to dismiss your civil suit. Please be advised, as I am sure your Uncle Joe warned you was forthcoming. The counter petition will contain a fraud allegation, as the images you sent Mr. Gillespie were confirmed to be recycled ultrasound from 2015. Greg was advised that he will suspend his counterclaim and related litigation once you promptly file to dismiss your civil suit and confirm that you are not pregnant. Signed, Greg from Woodnick Law. Prior to sending that, on Friday, the 27th of 2021, Seaberg CC'd Bowman and Woodnick, and it says, Laura, you should receive an email from Arc Point Labs of Scottsdale later today setting your appointment for a non-invasive prenatal paternity test for next week. Thank you. And then it's got, so Seaborg is a paralegal at Woodnick Law during this time period. So that is the filing and the exhibits of the response to seal, or response to motion to seal from Woodnick in the Gillespie v. Owens matter. Here is the audio that we are so thankful that Schnitzel Ninja broke down just this audio, and we are going to listen to it and then discuss.
Aren't you excited? This is what I've always wanted, kids. Oh my gosh. My mom was a twin also, so I always knew that I had the gene.
I have the gene. Don't.
No, I do. My mom's a twin.
Okay.
Oh, she is.
She doesn't want to fight.
So in that picture, the baby looks about 5 weeks and 4 days old.
They're fighting over it.
And that's,
5 weeks and 4 days. I estimated that. That's not what they... Greg, that's not at all.
No, I said no, the baby's about 5 weeks and 4 days. You didn't say that. It's not in the text. I'm just telling you. It looks like it's about 5 weeks and 4 days
What
old.
does that even mean?
That's exactly the day that we did it. So, like, this
5
is
weeks and 4 days? It says 5... I think it was 5 weeks. What are you talking about?
It says 5 weeks. Yeah, that's right when we did.
I estimated the date. What are you talking about?
Oh, you estimated the date.
Yeah.
Oh, you put it on there.
I estimated. They asked you when you think you got pregnant.
Oh.
Okay.
So you put it on there.
Okay, so...
They don't ask you that.
What were you trying to do other than be
because
sarcastic?
then if that was the case,
just excited
there
about
would be
having
a lot of ultrasounds that were wrong about dates. That's not how they
What?
determine any of it.
What are you trying to do? What are you trying to say?
What do you mean?
Because you're obviously not excited. So what...
So your pills didn't work?
I didn't say my pills didn't work. I got an ultrasound today.
I know, but they didn't work.
Did you not see that the other thing is like the tiniest thing you've ever seen? It
So
literally stopped the growth in
condescending
that.
rude.
Wait, what then? That's not a child. There's no twins in this picture.
Yeah, there are. Do you want me to zoom in on it for you?
Yeah, I don't know. There's no twins in this photo.
Yeah, there is.
Where? I don't know. I know how to read ultrasounds. This is a single baby.
You know how to read ultrasounds?
Yeah.
If you go down, here, I'll just screenshot it for you.
She doesn't like the sound of him possibly knowing how to read ultrasounds. She's very scared. So she's looking and sending it to him in that text message that we see. That we
So what? You want me to?
earlier.
What, do you think that? You want me to tell you I made a mistake, and you want me to? What did you say?
Well, you clearly were never planning to see me again.
Wait, you want me to stop and tell you? Let's go see the lawyer together.
Let's go what?
Let's go to the lawyer together. We'll talk to the lawyer.
That's what you would like to do?
Yeah.
You don't want to do... So you were just totally bullshitting
Wait, so
me?
you want to have a surgical? Oh wait, you want to have a? Wait, I'm just reading still. You want to have an abortion, a surgical abortion.
That's what I thought you wanted.
So you want to go have a surgical abortion?
That was what I thought you wanted.
So they're playing each other here. He wants her to admit she wanted the abortion. She wants
Greg, I'm
him
serious that I would
to
do a paternity
admit
test at 8 weeks. I'm not kidding
he
you.
wanted
I
that.
don't deserve this. I deserve you to keep your...
So wait, why didn't you answer the question about the photo online?
I did. What did you want me to say?
Why is it your photo?
It's not my photo.
Why not? You don't, wait, didn't you find it peculiar how
Now
similar
Greg
it
is
looks?
mad because
No,
he's
I
done
don't
the
find anything
reverse
peculiar
Google
with that ultrasound
image
photo. They all look
search.
the same.
They do?
And now he's
All
calling her
ultrasounds look
out.
virtually the same. I don't find anything weird with that.
You have experience in this?
With ultrasound?
They
Yeah.
don't all look the
I've had
same.
pregnant friends before.
Do you have any currently?
Yeah, why?
Who?
Well, it's my sister's friend who's supposed to be in her wedding, but she's due any day now.
Oh, that's cool.
Why?
Well, does she live in Phoenix?
No, she lives in San Francisco. Why?
Oh, so you got pregnancy friends?
It's not even a friend. It's my sister. Okay.
He's
Buick.
suspicious of
Exceptional
bitches,
by design.
and they're
Sign and drive is
don't know
here.
why that's on there. We are not sponsored by Buick either. That is the video. Or the thing. You've heard it a million times. All right, so that's where we're going to stop part 2. Something that I also don't think I mentioned earlier is when Owens had an email that was sent to her saying, oh yeah, you know, you're 3 obstetricians, and says that there's no past pregnancies in your history. Okay. What about Matt? What about Maraschini? Why aren't those pregnancies popping up in your history? So you lied in the Gillespie case saying you've never been pregnant before. Well, I mean, technically that is the truth. You hadn't been. But if you're sticking to your story, that would be a lie because you had been pregnant at this point. You had had a pregnancy with Matt and a pregnancy with Michael. So you should have 2 pregnancies on your record. And 3 different obstetricians. Are you freaking kidding me? Why do you doctor hop? If you were really pregnant, you wouldn't be doctor hopping unless for some reason you moved. Such as Dave Neal. They lived in one place. They had a doctor there. Then they moved to another place and they had a doctor there. That is a reason for a doctor change, not 3 doctors in 1 month. That makes no sense. And you want us to believe everything that comes out of your mouth. It's just not going to happen. We are ending with our quote of the day, and it is, "There is always something authentic concealed in every forgery." And we know Owens loves to forge. She likes to forge documents, medical records, ultrasounds, is what our suspicions are. And some have been confirmed. But the authenticity, the authentic part of those that is concealed, is that those might actually be a real lawyer agreement. We know those are real ultrasound images. So they are real in a certain sense. But the forgery is that, and the lie is that they are not hers. They are what they are, but they do not belong to her. They are not true. It is fake, and they belong to other people. It's like people are always talking about there's a little bit of truth in every lie, because it's easier to tell a believable lie if you factor in some truth in it. It sounds more believable. But when you've discredited yourself so much, whether you sound believable or not, nobody believes a word you say. Your word and stuff is almost all you have. Like, if people can't take you at your word, what's the point? Work on being honest, teaching our children to be honest, holding ourselves and our children and everybody, our friends, everybody accountable. Because the lack of accountability that's going around these days with people is part of the problem that we have with people just thinking it's okay to lie and fake things. I mean, it's on a huge rampage right now with different things from these younger generations. So if we can try to help fix that and get the world back to where people didn't think that this was just okay to do. And I get technology and stuff has made things easier. That still doesn't make it right. So that is it for me today. I will see you guys next time when we continue with the Gillespie series. Hit that like button, subscribe, leave a comment down below, and I will see you later. Bye.